I don't know if the judge accepted it or not, but I did object to it that he can't be a witness in the attorney simultaneously in the case. And
So did the judge didn't make a final ruling yet, or he ruled on some of it but not all of it, or something?
well, he couldn't rule on the vexatious litigant piece because the piece on that you got to be able to show harassment in order for that to be granted. And he was trying to use those pictures to say that I had been harassing McDonald's when that me and you we never discussed that. I mean, that's something that I think he would have wanted to bring up in a deposition or something and ask questions because he stuck his neck out on that. Yeah, that he stepped over the line with that one. So he made the statement saying somebody said I couldn't come back to McDonald's and that I had been harassing them. So he's trying to use the evidence that I submitted to you guys as evidence to show that I had been harassing McDonald's. And the thing is, he doesn't even know how those pictures even came about. He don't know who took the pictures. He don't know what date those pictures was taken on, and he don't know if my dog or my cat went up there and took those pictures.
You got a pretty well-trained dog and cat.
Yeah, so I'm like, for you to allege that I have been harassing employees at McDonald's, and they told me not. He didn't say who told me not to come back up there.
Right.
So you gotta, if that's the case, you need to put an affidavit together or a declaration under penalty of perjury making that statement.
Right. Did you tell the judge? What did the judge say?
Well, the judge didn't really, nail on it, but he told me to go ahead and put together my Second Amendment complaint, and I'm gonna bring it up in my Second Amendment complaint because he's already stepped on eggshells on that one. He's already in the. Go ahead.
Did he say when the complaint's due?
I got 20 days. I can knock something out like this in like 10 days or less.
Okay, all right.
Yeah.
So I got an update. Okay. It's been very confusing for me because I don't understand the form and all that. But, okay, I spoke to the person again, and here's what they told me. When they look on the, whatever it is, the website, right now it looks like there's a zero lien. But they're saying they can't, okay, the signature that you gave, Brian, on the, I think it was on the
23rd.
form
The 23rd was yesterday.
for the lien.
The paperwork I signed was yesterday on the 23rd.
Right. So that one, they don't need a notary public, but she's saying she can't submit it without also a signed settlement agreement, but we don't have a settlement yet. So, but she's saying that you can confirm it's a zero lien. When she looks, it's a zero lien, and you can call Medicare to confirm that there's a zero lien. And she said as long as you don't submit the medical...
Here's where you guys making a mistake at.
Okay.
The hospital in Long Beach, where I went and had my the emergency taken care of, they're the one coming after me. So you got it all twisted on who you're going after. It's the hospital where when I walked in the front door, it's their insurance company who saw me, who did all the x-rays, gave me pills and all that. They the one want the money.
Okay. So they're sending you bills. You didn't send the bills to Medicare or Medicaid.
I gave them my Medicaid and Medi-Cal card. They said that they refused it. So they're coming after me.
Okay. I think I understand. I'm sorry, I got confused. Okay. Let me tell them that, and then that means, okay, if that's the case, then I don't think that their lien can affect the settlement. But let me confirm that with the Gallagher-Bassett person. It would only be the Medicare, Medi-Cal that would affect the settlement. So my understanding is that if you guys settle, then the money can be paid directly to you. It doesn't have to be paid to the hospital. But let me double check that with them.
So it's the hospital.
Okay, so there is no Medicare, Medi-Cal. You didn't submit any bills, and they didn't submit any bills because they refused. Okay, I didn't understand that. Okay. Let me tell them that. That may help. Okay, that's good.
So that's
Yeah, no, I think that's good, because I think that means whatever settlement we agree to, hopefully, then 100% of that money will go to you, not to them.
the hospital has to be paid. Those are the ones who's coming after me.
Well, but I don't know. Let me find out. That's a legal thing I need to research. But I don't think that we are required to pay the hospital. Though, where did they file the lien, though? Where is the lien registered?
The bills that they're sending me, they're like, if you don't pay this, you can pay by insurance or a credit card or whatever. And then so after the 90 days, I guess, had expired, it's already been reported to my creditors. So it's on my credit account.
Yeah, but I don't think that McDonald's is required by law. See, I think, again, I need to double check with them, but I think only if it's a Medicare or Medi-Cal lien, then McDonald's is required by law to pay that first. I don't think that they're required to pay this hospital, but let me double check. Let me call them right now and double check. I don't know that they're in because they're Central Time, so I may have to call them tomorrow morning, but that's a really important point. So let me follow up on that.
Yeah, so I
understand better. Yeah,
that's why I submitted you guys the bills and everything, and the bill shows that the bills are coming from the hospiel. So you guys,
I understand. Okay. Well, I don't understand these things very well, and I'm getting a better understanding. Because when I talked to her, to me it was a little confusing. But now that I talked to you several times, and I talked to her, and I've gone back,
if you guys go back and look at
a better idea.
If you look at the bills I submit you, look at the heading of it, and then call those people and say, hey, we got a bill here that says this amount.
Right.
How do we go about paying it?
Right. No, I get it that the bill is going to originate from the hospital, but then the problem is I have to figure out, okay, was it submitted to Medicare, Medi-Cal, Medicaid, and where's the lien coming from? And that part I didn't understand. But you just told me something I don't recall you telling me before, which was
I shouldn't have had to tell you guys. I gave you a copy of the bills.
I don't have experience. I don't know how to look at the bill and figure out what's going on with the medical thing.
It's the same thing as you get your gas bill every month. It tells you amount. You know it's from California Edison.
Well, no, but,
it's the same thing.
Medical is a lot more complicated because you can have Medi-Cal and insurance and stuff like that. It's not the same thing, Billard. It's just a lot. Medical is more complicated. But anyway, okay, let me, some of these other people may have more, I don't have much experience in that area. But okay, let me talk to them again with that information, and then I'll get back to you, okay?
Sounds good.
Okay, but so he ruled on the demurs, so did he make that official yesterday? So you're going to have 20 days from yesterday, or 20 days from...
Right, 20 days.
Did he say when?
20 days to do the Second Amendment complaint. But the thing is, he's saying hold off on a Second Amendment complaint because he's thinking that the case may be settled and I won't have to file a Second Amendment complaint. So he's saying if the case settles, then therefore we just, I guess we can come back and put the settlement on record. But
okay.
So
I don't know. Are you guys going to be able to? Can you and Brian negotiate something, or how do you feel?
Well, like I said, we can get this bill out the way, and then you guys can compensate me for my pain and suffering, and we haven't even started talking about the pain and suffering. So that's where we're at with it. Just getting this credit.
So there's no deadline for the amended complaint. He didn't set a deadline.
I just told you 20 days.
20 days. Okay. All right.
Yeah, I can do it
from yesterday.
Pretty much from yesterday. Yeah.
Okay. All right.
But he gave you guys 45 days though.
To do what?
He gave you guys 45 days because he can't do a vexatious litigant. One, I don't meet the elements of a vexatious litigant. So I don't meet the requirements. Mm-hmm. Two, the same defendants that he's talking about, the case still pending.
Mm-hmm.
That case may not settle. That decision may not come down for another 3 months, from what I understand.
Mm-hmm.
But either way, he gave you guys 45 days to try and settle this case.
Oh, okay. All right. Okay.
So basically, that's where we're at, but your time pretty much is up within 20 days because if the 20 days come up on me, I have to file the Second Amendment complaint, regardless.
Right.
To meet my statute of limitations on that.
Right. Got it. Okay.
And so,
Alrighty.
looking at the evidence he produced yesterday to try and get that motion granted on the vexatious litigant, he's going to have a problem with that, because he's trying to use my pictures for his evidence to say that that's his harassment piece. I'm harassing McDonald's employees by going up there taking pictures, and then he doesn't even know how those pictures even came about. He need to put an affidavit or declaration on the court record explaining how those pictures came about before he can try to use them as his evidence to say this is a harassment evidence.
But if you submitted it to the court as part of your complaint, then we can use it. We don't need to separately authenticate it. That's the thing. If one side uses it, then the other side can use it.
Okay, but I submitted it in a judicial notice. The court denied my judicial notice.
Oh.
See? So if you want to go in and use that, then we need to get the judge to grant the judicial notice.
Okay, I didn't know he didn't accept the judicial notice.
Right. So you're like, hey, we want to use these pictures. Okay, so first of all, when you're going to use those pictures, we need to do the foundation on how those pictures came about. So if he's going to use them, he needs to know how those pictures came about, what date was they taken on, who was the one saying that they were being harassed. He has none of that. The courts can't rely on those facts because they're not an affidavit, they're not signed under penalty of perjury, and they're not signed by him. And if anybody at McDonald's made that statement, they need to come forward with an affidavit on what date was those pictures taken, what day they saw me in there taking those pictures. And then I'm going to tell you to go to my YouTube channel, and you're going to look at the video, and I'm sure you guys know anything about screenshots. You know anything about screenshots?
Well, I've heard about screenshot, but I have trouble doing screenshots because I always forget how to do it.
I can pull up a video.
I know people can do it.
I can pull up a video and let the video play, and then I take my hand and swipe it across the screen, and it automatically takes a picture of that video.
Screenshot. Oh, yeah. No, I understand what screenshots are because sometimes I accidentally do a screenshot on my cell phone. But I don't know how to do it on the regular computer. Although some people they've showed me before, I just can't remember how to do it.
Exactly. So when my girlfriend came over and when you're looking at the video and she showed me how to screenshot that, I went to FedEx, downloaded them, and put them in the paperwork. See, he has no background on how those pictures even came about, but yet and still he's standing up in court trying to testify to something. And he's committing fraud upon the court. He's committing fraud upon the court.
Well, but it's not fraud if you actually
you got it twisted.
I mean,
Trinzi versus Pacalao. Statements of counsel in their brief or arguments while highlighting for the courts are not sufficient for purpose of granting a motion to dismiss for summary judgment. ABA, conflict of interest, Rule 3.7, lawyers as witness. Paragraph A prohibits a lawyer from simultaneously serving as an advocate and necessary witness. The trial factor may be confused or misleading by a lawyer serving as both advocate and witness. That's what I objected to on record yesterday. Can't do it. Fraud upon the court. Concealment, suppression of material evidence. That video surveillance tape that you guys refusing to give me, you're borderline walking up on fraud upon the court. That's material. It's material evidence. The case is not going to go away until that video surfaces.
Let me call them tomorrow about that lien and double check on that. Because that's important what you told me.
Yeah, and so if he want to use those pictures, it'd be helpful if he can get me an affidavit or declaration. If he wants to come in here and make that statement using those pictures, for one, he need to get the court to grant the judicial notice on those pictures. Two, he need to do an affidavit or declaration on who said what and who seen me in McDonald's when nobody seen me in there, because I just told you. If you look on my
Okay.
YouTube channel, you look on my YouTube channel and you look up the McDonald's video I posted, you'll see that you can screenshot from those videos. So I don't need to go into McDonald's and make pictures and take pictures.
Okay. All right.
So that's
Hey, did you have a chance
misleading
to-
and false statements he's given to the court.
Did you have a chance to talk with Brian about settlement, or is that not? I mean, is that
He
something that you
wanted
guys
my
can talk about?
signature. He wanted my signature so he can find out how to get that $9,000 squashed, and then maybe we can talk about the pain and suffering part.
Okay. All right.
But as far as I'm concerned, I can have this Second Amendment complaint done within probably less than 10 days. So I'm just putting my affidavit together right now on this piece right here. We discussed it for the fraud upon the court, Trinity versus Pacalero, conflict of interest, Rule 3.7, lawyers as witness. So he want to come back in court and try that one again. He's just going to get stuck in the quicksand. I'm laying the foundation right now. I suggest he doesn't come back in the court and try that again.
Okay. All right. I'll let him know too. But I mean, you explained it to the judge, right?
The judge is all aware of everything. I told him about how,
Okay. All right.
in certain cases I did represent myself after I got rid of lawyers. So, and that's part of the elements of him trying to get me declared as a vexatious litigant. You have to be pro per within 7 years going and have at least 5 defendants within a 7-year period. And we don't have that. We only have 3. And that's Shepard Molen, the attorney Jason W. Kirk, and Swift Transportation. That's only 3 litigants. So he tried to throw Steve Charberger in there. Steve Charberger, the party he's talking about, was criminal. When they tried to get me for a 211 robbery, I fired my attorney and started representing myself, and I got out. They dismissed it. They went to trial and dismissed the case. He knew that. Had he been doing his due diligence and reading that stuff, he would have known that. So I don't meet those elements. Those elements doesn't fit me. And even if the judge had granted that yesterday, it would have gotten overturned based on the fact that he doesn't have the element of harassment. You got to have that. That's the main element they look for is the harassment. You got to have harassment. Without that, you can't get the vexatious litigant granted. And if you went over the paperwork that I sent you guys, I've already put that in my my paperwork, and I'm pleading. I put case law in there where the judge or reverse that in there, all that. So, I'm just getting warmed up.
Let me check with the lady on the lien, and then I'll get back to you on that.
Sounds good.
All right. Hey, thanks for calling.
Yeah.
What did you think of the judge? You appeared before a lot of judges before. Do you think he's fair and listening to people? And
this guy, you can't read him. You can't read him. 1 minute he comes at you this way, but he's been doing it so long he feels he can read you. But after I left there, he kind of changed his mind about me, though. Because he's out of Compton. He's a criminal judge out of Compton. So when I was telling him about the criminal side of my case, and I told him about how I represented myself and called for a Morrison hearing and how what happened, he was like, I can understand what you're talking about, because that's when he told me. He said, I'm a criminal judge out of Compton. And so, most people, they kind of look at people like, and they make an opinion on them within 5 minutes. And I keep telling people I just look like this. So after I get...
He was a PD for a while.
He was a police officer?
No, PD, public defender.
Oh, okay, yeah, he did say he was on both sides of the table, yeah.
Yeah, he was a public defender, and then later he was county council or something.
Yeah, he did. Now I remember he did say that.
Yeah, county council, but that's civil stuff, but he's done both. He's done civil and criminal.
Yeah.
But then I guess as a judge, he's probably done a lot of criminal stuff. Well, most judges have. Yeah. Because there's so much criminal work, out there that they have to do.
Yeah. So at the end of the day, he apologized for the way he came at me. And then, so like I said, he wanted to chop my head off. He wanted to kill the case, but had it not been for me doing my research on this stuff, it would have gotten appealed. I'd appealed it. I'd have took it all away. Just because of the fact that I don't meet the elements of vexatious. What is that? Vexatious.
Vexatious litigant.
Yeah, that part. So.
All right. Okay. Let me call them. It's going to be too late for them to call back today, but hopefully first thing in the morning she'll call me back.
Sounds good. So, like I said, I could probably have my piece done there. So. And then, like I said, he gave me 20 days to file it, and he's hoping that I don't have to file it. Hopefully, the case will get settled.
All right.
So, like
all right, let me check up on it, and I'll stay in touch with you. Well, that's good. I'm glad you got in, and it's weird because in Sacramento they told us you absolutely can't come to argue.
Well, I don't understand.
2 or 3 LA courts. Oh, yeah.
He got in, Brian got in the courthouse yesterday. When I told him the defendant's name, they still say, oh, he ain't on the list. It just, I happened that this other female deputy walked by. She goes, oh, yeah, courtroom B is open. You can go up there. You know, so I'm like, how did he get up? How did he get up there? The fact that he's an attorney?
Yeah.
He would have had to be on.
That's the thing, that people are going by, it's biases that if you have a suit on, then you can get in, and if you don't have a suit on,
Well, I was actually, planning on putting on a suit or whatever, but I just said screw it. I just, good thing my case was number 6 because I got in there like just in time.
Yeah. Because I thought it was 8:30, but
No, most judges take the bench at 9 o'clock.
Oh, okay.
That's all everywhere. Most judges take the bench at 9 o'clock. It's very rare that you get one of them to take the bench at 8:30.
Yeah. So hopefully the other LA courts, and the weird thing is about the trials, they've been saying that, there's not going to be any civil trials for a year or 2, that's crazy, because they said they want to do all the criminal trials first. And it's like, yeah, criminal trials are important, but what about, civil trials are important too. I mean, can't we have a balance?
Well, like I said, they're opening everything up slowly. They got trials on record. I heard this judge yesterday talking about October, so they're setting theirs up for October. It was only like 3 people in the courtroom, so it's just, they're picking days.
Yeah, I think probably a lot of people do prefer to appear just by Zoom or whatever, so I guess, it's probably safer, but.
So was that a trick that you guys sent me the Zoom ID number and?
No, of course not. I didn't even know about it.
Well, somebody sent me. Somebody sent the Zoom ID number to me saying that you have a court date, which I knew I had a court date yesterday at 9 o'clock. So everything matched up, and so got the IP number, and so I'm sitting here waiting to see if the judge is going to come on, and I'm like, who are these people? Come to find out, it ain't what I needed.
It must have been the court. It must have been the court, because we don't. We would never do something like that.
Well, good thing I was just down the street, because like I said, I was just right down the street.
And then Brian said, I don't know if he ever did get, when he spoke to me, he said he didn't receive any email. So he was confused too. Yeah,
well, it worked out, so I got in there. It's all good. I got in there, so yeah.
Yeah, because if you had stayed home and then tried to do the Zoom, that's not good.
Well, had I not been able to get in the courtroom, then I guess the case would have got dismissed based on me not showing up. So that was a good tactic, but it just didn't work. Good tactic, just didn't work. Keep telling you guys, God is on my side. Keep telling you, but it's okay.
Okay. Well, no, I wasn't trying to do anything dirty. I just brought the motion in.
It's okay. We made it there. That's all that matters. Once you on, once you off. No, I didn't get a chance to brush my teeth. None of that.
Plus, I wouldn't send you an email because you told me a long time ago that I can't communicate with you by email, and then you don't have an email. It don't matter who sent it.
It don't matter who sent it. And that's why I didn't bring it up in court, due to the fact that I couldn't prove who sent it.
Yeah.
So
I wouldn't send something like that.
I look at it this way.
As a matter of fact, when you called me, I said, I think we're going to go in person. So why would I, if I wanted you to cheat you, I would have said, oh yeah, we're going to do Zoom, and then I would go. But I didn't, I didn't say that.
Yeah, I'm
what I
looking
mean?
at it, no harm, no foul. And the reason I would have rather do the Zoom because everything would have been recorded. See,
Right,
so
right,
that would have
right,
saved you money from having one of those hand typing people in the courtroom.
right. Well, the only reason I don't trust the Zoom is that stuff goes wrong. They can't hear you. You know, the court call, sometimes they can't hear you. Your phone gets dropped. So if you're there in person, it's a little bit safer. I mean, it's more dangerous from COVID, but it's a little safer from, hey, I'm right here. You know, you can't say I didn't show up.
Yeah, I mean,
So that's
you know, Torrance here, I'm just like not too far from Torrance, so it was a hop, skip, and a jump.
yeah. No, it's might as well. Over there, you might as well.
Yeah.
So, all right. Well, anyways, but yeah, no, I'm not trying to win dirty or anything like that. I don't think that's fair, and I wouldn't do that to you.
Oh,
so.
you know, I would have appealed it. I would have appealed it. Yeah. Even if he'd have ruled it the way he wanted to or whatever, just, you know, ignoring all my evidence, I still would have appealed it.
Right.
You know, because I'm used to state judges doing that anyway. Because a lot of them are biased when you come before them as a pro per litigant. A lot of them don't like that, so they're gonna rule for the attorney because that's one of his advocates. That's one of his buddies from the college is carrying on stuff. So he's like, yeah, I'm not gonna let a pro per litigant win against an attorney. See, so that's the way they do that. Which, you know.
Yeah, no, I know what you're talking about because I get a case now up in Santa Cruz, and I just feel like the judges, not just the one judge, but all the judges, they're biased in favor of this one guy. He's passed away, but he was, you know, pretty successful locally. I feel like they're really in his favor, and they're against my client, and we're getting all these rulings against us. And even, you know, it's not 100% that we should be winning everything, but it's, you know, I know the law really well, and it's a lot of these rulings are wrong, and it's just. And they've been really rude, and it's like what you're describing. But anyways, all right, okay. I'll be in touch. Let me call them tomorrow, and then we'll hopefully make some progress.
Okay, sounds good.
All right. Hey, thanks for calling. You take care now.
You too.
Okay. Bye-bye.
Bye-bye.